or let them put the officers on notice. Now, cops, when they ask you for identification, if they are only willing to accept government-issued identification, and yet we don't have any obligation to have government-issued identification, then the circumstance which is created is that people are getting government-issued identification just to avoid being beat up by the police, and that shouldn't be the case. We should be able to create our own identification, issue it ourselves, and serve them with copies and say, here's my identification, this identifies me, and yet no party issued it, and so no party would have a legal claim of authority over you. However, they don't like that. They insist on government-issued identification. You don't have that, they bring you to jail. This is the Canada we're living in because the people who are making the words, who are creating the statutes, these people know that we have no obligation to have government-issued identification. We have no obligation to hold it, no obligation to produce it upon demand. But they craft words that are ambiguous enough that they would cause these police officers who are heady in their desire to protect us from our own rights. These people can interpret it in a manner that allows them to think that we have a duty to have government-issued identification and produce it upon demand. This has got to stop. If you look at what some of the requirements are for flying in Canada, we have a right to travel. But if you try flying in Canada nowadays without government-issued identification, not merely government-recognized or provided, actual government-issued, then you're not allowed on the plane. And what's very sneaky about it, by applying for government-issued identification, you abandon your right to fly in exchange for a privilege to fly, requiring government permission. And when they put you on the list, the no-fly list, what they are doing is saying, we have revoked this person's permission to fly, which means you're not exercising a right at all. But if you don't have government-issued identification, there is simply no way for them to legally claim that they have revoked your permission because you weren't relying on their permission. It all boils down to holding identification issued by a party and the amount of authority that grants the issuing party over you because you decided to submit and apply.
Freedom, freedom for free.
Now, these people are hired as not so much as peace officers, but as policy enforcement officers, revenue generators, money collectors. They're limited by the peace officer status. In a common law jurisdiction, people have the right to refuse intercourse with a peace officer who has not observed them breach the peace. And that means you are not obliged to identify yourself to a peace officer upon demand unless they have observed a breach of the peace. So the question is this: are we obliged to engage in intercourse with a peace officer who has not observed us breach the peace? I say we're not. I say we're free human beings, and as long as we're acting peaceably, those peace officers should go find something better to do. Now, this is a big one, and I'm sure the courts aren't going to like it, but it's key to the entire situation because these courts are using these officers of the courts, these RCMP officers, and they are generating revenue. It's like, who let the dogs out, and why the hell aren't they on their leash? And if they're not on the leash, put a muzzle on them. Do these courts require the consent of both parties to the adjudication or not? It's a very simple question. I know the answer to it. And the answer to it, you better not abandon equality and its paramount importance in a common law jurisdiction. So answer that question. Do your courts, those courts that you're operating, providing adjudication services, do you require the consent of both parties to the adjudication? Or do you claim the right to govern your fellow man in a common law jurisdiction without their consent? Now, if you read the Criminal Code of Canada, you'll find a section in there very interesting. It deals with de facto and de jure. And essentially what it states is that it's no longer a crime to obey the orders of a de facto government. Now, in the absence of this section, obeying those orders would in fact be a crime. You could be charged for it, and refusing to obey those orders would clearly not be a crime. Now, what they have done is they've stated quite clearly that it's no longer a crime to obey. Has it changed the other part of the equation, however? Does it state clearly, specifically, and unequivocally that disobeying the orders of a de facto government is unlawful? You know they're all de facto, right? I've seen a lot of people argue against the free man perspective, and they try to argue, well, you're in Canada, obey the Canadian laws. But what they fail to do is distinguish between the actual law, which says you won't harm, damage, or use fraud in your contracts, and a bunch of statutes and acts which are really only applicable against those people who secure benefits from the government by way of the fact that they have a social insurance number or they hold government-issued identification. Now, many people say because you're in Canada, you're bound by Canadian society. But the thing is, we have a right of association. And that means I have a right to stay in Canada and not be associated with any society whatsoever. In my position, a society is a number of people joined by mutual consent to deliberate, determine, and act for a common goal. The question is, am I a member of a society merely by virtue of my physical presence in a geographical location? Or is consent required to be a member of a society? Now, if consent is required to be a member of a society, can we be ordered to leave the place of our birth because we don't consent to the corporations ordering us to be their employees and then governing us like that? The next one down, the corollary, would be, can a society be deemed to exist if it doesn't have a legal name?